Welcome to today's program titled EEOC's Dramatic Turn 2026 Enforcement Trends and Employer Exposure. At this time, all participants are in a listen-only mode. For those of you who are logged into the live web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees within a day or two following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Chris DeGroff. Chris, please go ahead.
Thanks, Kate. Welcome everyone to our 2026 EEOC webinar. I confess I've lost track how many years we've been doing this, at least 15. My name is Chris DeGroff. I'm a partner here in Seyfarth's Chicago office for about 30 years now. I'm for the most part focus on government initiated actions, and I am co-chair of our complex discrimination litigation group. I share that title with Andy Scroggins, who I'll pass it over to now.
Thanks, Chris. I am also a partner in our Chicago office, and with Chris, co-chair our complex discrimination litigation group. And also, like Chris, like to focus on EEOC initiated litigation, but also have a class and collective action practice in other areas too. And I'll kick it to Sam.
Thank you. I'm Sam Brooks. I'm in the DC office. I work mostly with Chris and Andy on complex discrimination litigation and government initiated litigation and investigations, also along with James.
Thanks, Sam. I am James Nasiri. I'm also an associate in our Chicago office, member of the complex discrimination litigation group, and I've been involved in preparing the firm's EEOC initiated litigation report since 2017. Chris, to start us off today, can you tell us what we'll be discussing?
Absolutely. Other than what the heck's going on over at the EEOC, we'll be kicking things off discussing the EEOC's lineup, which I think now more than ever is going to be important for employers to understand. We'll also talk about charge data by the numbers. We'll be digging into what the litigation statistics tell us. We're going to look at the EEOC's stated strategic priorities and what we're actually seeing from them based on their litigation, and talk a lot about what the more emerging issues in, and importantly for you all, what you can expect from the EEOC in 2026. We have the next slide, please. So as promised, let's start with talking about who is the EEOC. Right now, there are 3 sitting members of the commission. Just recently now have a quorum. We have the chair of Andrea Lucas. Andy, I think you'll agree, there are a few EEOC chairs that have had the same singular impact on the commission as Chair Lucas. She was, of course, nominated by President Trump, and she's been very clear she's going to disavow DEI. She has a definite angle on religious discrimination. Her stated purpose is to restore equal opportunity for all American workers. and not mentioned here, but also has taken a very strong position on pregnancy discrimination. Andy, how about Commissioner Cottigal?
Sure. And I would add with Chair Lucas that she had a stint before she was chair, and we could see her taking a lot of these positions previously too in her votes. She just didn't have control over the entire commission like she does now. Commissioner Cottigal is another holdover from before. She was a Biden appointee, confirmed and sworn in the fall of 2023. She's got a term that runs through July of 2027. Before she was on the commission, she was in private practice at a plaintiff side focused firm and sort of made a name for herself as one of the co-authors of the Inclusion Rider, which you may recall was intended to improve equal opportunity in the entertainment industry. Got a shout out from Frances McDormand during an Oscar speech. She is the sole remaining nominee by President Biden because President Trump dismissed the other two Democratic commissioners. And so for most of 2025, it was just Commissioners Cottigal and Lucas, and that left them without a quorum. Our newest commissioner is Brittany Bull Panuccio. I don't know if that's actually how you say her name, but hopefully that's close. She was Trump appointee, confirmed and sworn in October of 2025. And really, they've just gotten the commission going with a quorum at the start of 2026. Her term is going to run through July of 2029. Immediately prior to being a commissioner, she was an AUSA in the Southern District of Florida. But in Trump 1, she also had roles in the administration. She was at the Department of Education and involved in the Civil Rights Department for DOE. And Chris, I'll kick it back to you to talk about our next nominee.
Yeah, and the next person we wanted to bring up is not a member of the commission. He's not a commissioner, but he is the nominee for general counsel. And historically, the role of general counsel at the EEOC has been a pretty important one. Time will tell whether Chair Lucas is going to continue to hold the same amount of power over the folks in the field, including the general counsel. But the nominee is M. Carter Crow. He would be the top EEOC attorney with the commission as he awaits his acceptance into that role, his confirmation. He's still practicing at Norton Rose Fulbright as an employer side lawyer. Now, what does that mean for folks if he, and we have every reason to believe he will be eventually confirmed, he will know employer's playbook for one thing, but also might be able to bridge the gap and be able to talk to employers in a way that perhaps some of his predecessors have not. But we will wait and see. By this time next year, we'll have a better sense of what kind of footprint Mr. Crow will leave on the EEOC. All right, next up is, let's take a look at the charges. Let's throw that over to Sam. What can we learn from those, Sam?
Thanks, Chris. So the most recent charge data that we have is from fiscal year 2024, which was October 1, 23 through September 30th, 2024. We haven't gotten new data since then. And generally what the charge data demonstrates is how workers feel about how they're being treated by their employers as compared with the EEOC merits filings, which we'll talk about in a moment, which reflect the EEOC's priorities. In fiscal year 24, there were over 88,000 charges filed, and we've seen that number increasing year over year leading up to fiscal year 24. Generally, retaliation is consistently the most common allegation in EEOC charges, followed by disability and harassment. And also generally, disability and age claims have also been generally increasing over time. One thing to note is fiscal year 24 saw a continued drop in religious discrimination charges post 2022, where we saw a high in religious discrimination charges, which was attributable to religious objections to COVID-19 vaccine policies. But since the waning of policies and the now that COVID is more or less in the rear view, we've seen those kinds of claims decrease. James, what else can you tell us?
Yeah, thanks, Sam. To build off of those insights and to call out one point in particular, harassment charges are a category that we've seen rise significantly. 2024, we saw almost 36,000 charges alleging workplace harassment, and that's not only a 12% year-over-year increase, but it's also the highest number of harassment charges that we've seen from the EEOC since they started tracking the number of harassment charges in 2010. Another category that I think is worth calling out is race, national origin, and color-based claims. These are another category that have continued to increase year over year since 2022. And race discrimination charges alone accounted for 34% of all charges in fiscal year 2024, with national origin and color claims coming in at about 9% and 8% respectively. Just a quick preview, we'll get to this in our litigation statistics here in a couple minutes, but despite this persistent increase in race, color, and national origin-based charges, the EEOC's litigation wing has not placed an emphasis on these type of claims, at least in fiscal year 2025. So, from a charge number perspective, I think our takeaway is that we continue to see more charges year over year, and this spike of 88,000 in 24 really stands out when you look at years past. We can see the bar graph, but prior to the COVID pandemic, we had seen about 60,000 charges, so that number is really spiking. One other point I'd like to call out about the charge data relates to location. So the EEOC puts out not only data based on types of claims alleged in charges, but also where these charges are coming from. And at a surface level, our geographic hotspots are sort of what you would expect. They're highly populated states like Texas, which led the charge again this year with over 9,000 charges, followed by other highly populated states like Florida, California, Illinois, and Georgia. But what we like to do when we get that state data is compare it to state population data and see when we adjust charges for state population, which region of the country may pop out in terms of charges per capita. And over the last few years, the trend here has been that the southeast region of the country continues to lead the way in terms of charges per capita. And in 2024, that showed up as Arkansas leading the way in per capita charges. Arkansas saw nearly 6 EEOC charges filed for every 10,000 individuals living in the state. And other notable states in the per capita category included Nevada, Georgia, Mississippi, and Texas. So that's been a trend the last few years, that the southeast region of the country, at least when adjusted for state population, is fairly active in terms of EEOC charge filings.
I'm going to jump in. Just one thing to remember, folks, is that the EEOC doesn't control what charges get filed, right? So the charge data in one way reflects more of what the workers are feeling versus what the EEOC is prioritizing. But a couple of things. One is that while Chair Lucas or the commissioners cannot choose which charges are filed, they can impact how those investigations are prioritized in the field, which of the investigations are going to be more rigorously pursued, what theories they're looking for, and what we've seen even more recently, which is a pretty stark departure, is you have Chair Lucas actually soliciting charges for particular areas. We've seen two in particular. One was recently she did a press release where she said, "Are you a white male that feels they've been discriminated against? We want to hear from you. You may have a claim," which with the intent of let's drive some more of those sorts of charges. She also made some public statements about women who might be sharing bathrooms with trans employees, and whether or not that might create a charge. So clearly she's trying to drum up some additional claims in areas that are important to this administration.
Yeah, I agree with all that. I would also, go back to what Sam and James mentioned, that these numbers are lagging behind, and all these numbers we see here actually came in while Chair Burrows, Biden appointee, was in charge of the commission. We know from people who are at the agency that she was very interested in driving up charge numbers because in her view, this was justification for getting more funding for the agency. So I think when or if we get additional charge data, it will be interesting to see how the volume goes down under this current commission and whether those efforts by Chair Lucas and others to solicit certain types of charges will actually be reflected in the data, or whether we'll see people continue to file charges, based on how they feel they're being treated, and in a pattern that we've seen, pretty consistently over the years. I think, and Chris, chime in on this too, if you like. Another thing that we've seen become more common at the EEOC is the use of a commissioner's charge. And this was a little used tool in past years. If you go back to 2020, there were fewer than 5 commissioner's charges filed per year. But it's a tool that Andrea Lucas began using as a commissioner and has continued to use as chair. And a commissioner's charge is in some ways just like a regular charge. It has to be based on, facts that somebody believes that they know of ongoing discrimination or harassment. But it's filed by the commissioner, signed by the commissioner, and then given to a regional office to investigate. And, anytime your boss, I think, gives you a charge, you're probably going to look at it a little more seriously than just somebody who walks in off the street and files that charge. And we saw in the most recent year that this was reported, almost 35 charges filed. And we know that that's a tool that they're continuing to use now as a way to kind of pursue these administration priorities that we're going to continue to talk about.
Yeah, I completely agree that the commissioner's charge is what I would call the big kahuna, to use a legal term, of charges. And if any of our listeners are subject to a commissioner's charge, that's something that you have to pay attention to and treat with the care it deserves. Okay, let's maybe go to the next slide. Let's talk about some of those litigation numbers we've been alluding to.
So the most recent litigation information we have is from fiscal year 2025, which was October of 24 through September of 25, which is definitely more recent data than we have for charge data. What we saw this past year was a significant drop in filings as compared with 2024. And in fact, this was a 10-year low for merits filings. There were just 93 merits filings last year as compared with 111 in 2024. As you can see on the nifty little chart on the slide, we generally see a consistent number of filings from October to August over the fiscal year. And then every year there is a consistent spike in September before the end of the fiscal year. And 25 kept with this pattern, but overall, the number of filings were lower. There were only 35 filings in September of 25 as compared with 56 in September of 24.
And
next slide, please.
Yeah, before we go
Sorry.
move from that slide, I just want to, this might raise the question for you all. All right, so what's the big deal? It's the EEOC only has so many litigation bullets in the gun, and the likelihood of us getting targeted, what's the chances of that? So I have 2 answers to that. One is, if you happen to be one of the folks that do get targeted, it's a really big deal. The cost of expense, the operational burden, the brand exposure in particular, it's a big deal, right? But also we've seen that where the EEOC leads, the private plaintiffs bar follows. We see copycat litigation all over the country when we see the EEOC drumming up this sort of interest around a particular area. So I would, under the heading of why do we care, it's because it's not just the EEOC that's bringing these kind of cases, but slipping right in behind them is the private plaintiffs bar as well. Sorry, Sam, we can go ahead to the next slide.
So over the years, Title VII is consistently the most commonly cited statute in EEOC-initiated litigation this year with 51 filings. And that this year broke down to 37 cases involving sex or pregnancy claims, 23 cases involving hostile work environment claims, 22 cases involving retaliation claims, which aligns with the fact that retaliation is the most common claim in charges, 11 religious discrimination, and 3 race or national origin. The next most commonly cited statute in EEOC industry litigation is the ADA with 34 filings this year. We saw this year an increase in PDA, Pregnancy Discrimination Act, and Pregnant Workers Fairness Act claims with the introduction of the PWFA in 2023 and the final rule implementation in 2024. And this also aligns with Chair Lucas's stated priorities, which we will cover in a bit more detail in a moment. Interestingly, there were no EPA, Equal Pay Act cases in 2025, and other trends that we saw this year were, again, the number of ADA cases has been steadily increasing over time. Andy, anything to add?
Yeah, I think when we look at the 2025 figures, we have to remember that most of that period of time fell when the commission did not have a quorum. And a quorum, at least at that point, and we'll talk about this again later too, last year under the litigation delegation rules, without a quorum, the EEOC couldn't pursue its biggest cases. It couldn't pursue cases on behalf of a class or a collective, couldn't pursue cases that would require significant outlay of agency resources. And we also were looking at a scenario where the regional attorneys around the country were adjusting to a new administration. And what we saw over the course of the year was basically small ball, right? So we were getting smaller litigation matters on mostly not controversial issues. And I think that that can be attributed to what the regional attorneys had approval to file, but also what they felt comfortable filing. They weren't pursuing administration priorities so much as things that they believed were consistent with the kinds of work that they'd done in the past, maybe not pushing the boundaries, but things that they thought would have them acting in a manner that was not going to bring disapproval to them from Commissioner Lucas, but that maybe also didn't feel uncomfortable to them, inconsistent with the way that they pursued the job in the past. And so, again, I think this explains the ADA cases, which are mostly not controversial, not boundary pushing. It explains the pregnancy discrimination cases, where, again, that's a Commissioner Lucas priority as being the only commissioner to have ever given birth while in that role. I think we'll start to see this change over the course of the next year. We've already started to see it change. I think with that, we could move to the next one.
So just a bit about where the cases were actually filed and by which district office the cases were filed. So the Chicago office led the way this year with 11 filings after trailing with their number of filings in recent years. And Philadelphia, Indianapolis, and Houston were a sort of close second with 8 filings each. And interestingly, traditionally busy offices like LA, New York, and San Francisco were quiet this year with only a few filings each. This really is in contrast to the Obama-era EEOC, where the West Coast offices in particular filed dozens of lawsuits annually. Chris?
Yeah, I just point out that this slide is a good illustration. The EEOC is broken up into these 15 different districts, and each one has its own personality. It has its own leadership, and up until this year has operated with a certain amount of autonomy. Sometimes these districts actually compete with one another in a variety of ways. The folks that are heading up these offices are often career EEOC professionals, and they have truly drank the Kool-Aid and can be very passionate about particular views that they have on certain topics. One thing that we did not see this year is any of those regional leaders really breaking from the pack or going out with what I would call more of a rogue filing, where they have brought a case that they thought was important for their region, even though it didn't connect up completely with the political agenda of this administration. So, long way of saying they towed the line. And as of this January, they have to, because all of these suits have to be voted on by the commission. But I was actually pretty surprised that some of these regional attorneys didn't sneak in at least a couple of lawsuits that they found particularly important for their agendas. And speaking of what's important for the EEOC, why don't we go to the next slide and talk about what the EEOC is focused on. So what we have up here, and I know it's a busy slide, it's hard to read, but for reasons I'll get to, it's not all that important to read it. This is the current strategic enforcement plan for the EEOC that is supposed to run through 2028. Safe to say, I think that this is on the chopping block and it's going to be on probably a short list of items that Chair Lucas is most likely going to be changing in the near future. We have a number of these priorities that are on paper, but how they're actually being pursued is quite different. For example, if you take a look at the first strategic enforcement priority, it talks about eliminating barriers in recruiting and hiring. That's been a standby theory for the EEOC for a long time, but under the current administration, disparate impact claims have been completely jettisoned. The EEOC is not pursuing those anymore, and that was the real bread and butter of how to do a recruiting and hiring case, is to dig into the statistics. Without disparate impact, it's going to be very difficult, or I guess it deprioritizes what was ordinarily a pretty high importance topic for the EEOC. Also, protecting vulnerable workers. That used to mean non-English speaking immigrant populations who didn't otherwise know their rights, and the EEOC felt that they needed protection. There's been an almost 180 flip on that. And so instead of protecting some of these itinerant workforces, it's now the rally cry is anti-American sorts of theories. So those are just two examples of where we're going to see. We'll talk about the emerging issues in a little bit. James, how about equal pay?
Yeah, sure thing. And Chris, along those lines of what you mentioned, equal pay is another priority that remains present in the EEOC's strategic enforcement priorities on paper, but in practice we just aren't seeing that play out. This is another priority that's consistently appeared in each iteration of the EEOC's SEP. The focus has changed. It was previously limited to sex-based equal pay issues and has since been expanded to pay discrimination based on any protected category. And the EEOC has also included more language to expand on how it intends to combat equal pay in the workplace and the types of policies that it intends to flag. But all that said, to your point, Chris, this focus just does not appear in the EEOC's practice. As Sam told us, the Commission did not file any Equal Pay Act claims this year, so this appears to not be on the radar for current EEOC leadership. And to quickly touch on, going down the line, the fifth priority here, preserving access to the legal system. This is another priority that has consistently appeared in the EEOC's priority plans. And really the crux here is focus on retaliation. The EEOC always includes some language in its priority documents about combating policies that discourage employees from reporting violations or filing charges, participating in investigations, things of that nature. Here we have seen about 35% of lawsuits in fiscal year 2025 involve a claim of retaliation, either under Title VII or the ADA or a pregnancy statute. So this priority, preserving legal access, does continue to be reflected, at least in the EEOC's filing data. Andy, do you have anything on our sixth priority?
Sure. So sixth priority relates to preventing and remedying systemic harassment. And certainly the EEOC has continued to enforce the anti-harassment laws, but the way that they've done that has taken a different shape. If you can read the fine print there, one of the or some of the types of harassment that they mention are preventing harassment based on gender identity, sexual orientation, and we've seen the EEOC back away from any claims that would be predicated on gender identity or sexual orientation. We actually saw them withdraw from some pending litigation that was based on gender identity over the last term. So probably the strongest signal that the EEOC has sent on this topic was the recent vote by the commissioners to withdraw very extensive guidance on harassment that had been published under the Biden administration. They threw out the entire document. I believe that the reason why they did that is because some of the scenarios and examples and case law that were provided related to harassment based on gender identity or sexual orientation. And rather than try to, do a more targeted revision to the document, they just got rid of the entire thing. At the same time, though, Commissioner Lucas did make a statement saying, the harassment laws are still out there. This is not opening the door to harassing employees. We're going to continue to enforce those laws, but they weren't comfortable with the guidance, both in the examples that were provided and even just offering information in that format through a guidance document. So harassment still not allowed, but EEOC with a different view on it. And I think we can go to the next slide and dig into the emerging issues.
So the first emerging issue is pregnancy accommodations in PWFA guidelines. And as Andy mentioned a short time ago, Chair Lucas has been known for emphasizing issues related to accommodations for pregnancy, childbirth, and related medical conditions. And in the most recent strategic enforcement plan, which Chris, Andy, and James just told us about, it includes a focus on protecting workers affected by pregnancy, childbirth, and related medical conditions under the PWFA, PDA, and pregnancy-related disabilities under the ADA. And in fact, as discussed in 2025, the EEOC filed 10 PDA or PWFA lawsuits under Title VII. In Chair Lucas's statement regarding her position on the Commission's final regulations implementing the PWFA, she explicitly rejected the Commission's broad interpretation of the PWFA, in the final rule. She said essentially that she thought the final rule erred in conflating pregnancy and childbirth accommodations with accommodations of the female sex, biology, and reproductive system more generally. Specifically, Chair Lucas thought that it was too broad and extended related medical condition to virtually every condition, circumstance, or procedure related to the female reproductive system. Of note, the final rule defines related medical condition very broadly to include things like termination of pregnancy via miscarriage or any other way, and menstruation, among other conditions or procedures. Reversing or revising the final rule requires a vote of the Commission, which Chair Lucas has said she will, in fact, seek. Andy?
Sure. Thanks, Sam. We've also seen this EEOC with a focus on religious discrimination, but again, with their own spin on it that differs in some ways from what we've seen in the past. Previous iterations of the EEOC would have been most commonly found pushing the boundaries of what would be covered by Title VII's protections related to religion, whether by focusing on minority religious groups, for example, or maybe less popular beliefs. What we've seen the focus turn to with this EEOC is to looking at anti-Christian bias, and we've seen the EEOC join up with Department of Justice in efforts to prevent or eradicate anti-Christian bias. There's been a very strong focus on anti-Semitism, and we've seen announcements from the EEOC of settlements with universities, for example, with very large payouts to try to provide some restitution to people who've been harmed by anti-Semitism on these campuses. We have seen through some public disclosures that the commission is pursuing large investigations against other educational institutions, seeking information about the religious composition of their student body, of people working for the schools, people involved in study programs related to religion. So we've seen them taking a very aggressive and shifted view in this area. We've also seen them pursue more cases related to accommodation of religious beliefs. I've seen in particular wearing religious garb at the workplace become an issue in litigation, or accommodating somebody's beliefs as it relates to, say, for example, vaccines. So that's been a change from the prior EEOC, which really didn't seem to want to get involved in the vaccine issues to a great extent. We've seen more willingness from this EEOC. Another priority area that we've seen that is new is a focus on anti-American bias. And over the course of the first year, there's been relatively little activity here. We've seen Chair Lucas make public statements and to encourage people to bring charges if they feel that they've been treated differently because they are American as opposed to other types of workers. And then we've seen them selectively emphasize other litigation that had been in the pipeline or charges that have been in the pipeline. So one of the first settlements that we saw under the new administration related to a hotel in Guam that was allegedly favoring Japanese employees over American employees. And Chair Lucas, in the press release announcing the settlement, was quick to kind of try to characterize it as bringing suit on behalf of Americans and in opposition to anti-American bias. At the end of the last fiscal year, we saw a lawsuit filed where the allegation was that African-American workers in a warehouse setting were treated less favorably, got less favorable assignments, were paid less than foreign nationals who had been brought in on visas to work at that same facility. And I expect that we'll see more of these types of suits as we go forward this year and as the commission has had more time to solicit these types of charges, to investigate them, and to tee them up for litigation. James, pass it to you.
Yeah, thanks, Andy. So the fourth emerging issue we have noted up here, the use of data in employment decisions. A main component of this is artificial intelligence, or AI. As you know, many of us have seen, AI has now moved into the mainstream with respect to recruiting and hiring practices. And this issue has previously been identified as an emerging issue that the EEOC is focused on in its strategic enforcement priority documents. This language has expanded the EEOC's scrutiny not only on AI and machine learning and automated systems, but in all uses of technology in employment decisions, mainly with respect to things like recruiting, putting out job advertisements, initial screening of candidates, things of that nature. The caveat here, and Chris hinted at this before, is that a key to many of these enforcement efforts is the theory of disparate impact liability, which allows plaintiffs to challenge what appear to be neutral hiring practices that they claim allegedly result in statistically unequal outcomes for certain protected groups. When the Trump administration put out Executive Order 14281, which effectively directed all federal agencies to deprioritize disparate impact theories, the EEOC responded by putting out its own press release expressing its intent to comply with this executive order. And shortly thereafter, the commission withdrew AI-related guidelines and also reduced staff who previously supported disparate impact investigations. In terms of what employers can expect here, I think on the EEOC's end, we can expect the EEOC obviously to shift away from disparate impact claims, but to still pursue, recruiting and hiring claims or claims related to data usage where the claims suggest any intentional discrimination, which could be packaged as pattern or practice claims. And of course, any charges that come into the commission that claim that technology was used intentionally to discriminate against an employee or an applicant, those charges will likely receive priority handling and heightened review at the commission. Chris also hinted at this earlier that often we see the private plaintiffs bar fill gaps where the EEOC steps back. And I think it'll be interesting to see the degree to which the private plaintiffs bar steps in on this issue of use of technology and data and employment decisions. Given the costs of championing efforts, large-scale efforts like this, when we don't already have agency support with respect to investigations and initial data assessments. So all that said, while it is unlikely the EEOC will pursue any disparate impact cases related to AI or use of technology, private plaintiffs will still likely pursue this, and state and local laws still touch on these issues, which still make it important for employers to monitor, their AI tools and to understand how any vendors may use AI or technology in their practices. So now that we've talked through, Chris, do you have a
yeah, just one last point on that. The EEOC, when they backed away from disparate impact, also said, but wait a minute, statistical data still has its place. We still are going to use statistical data in disparate treatment claims to prove up those sorts of, and the difference between disparate impact and treatment is a fairly fundamental one. But I still think that the EEOC is interested in data, but we also have learned that lots of the back of the house number crunchers at the EEOC were the first ones to go when they started cutting resources to the field. So whether or not the EEOC truly has the folks to do the sorts of statistical analysis in-house, at least, is we haven't seen a whole lot to evidence one way or another. But I just raise it as the EEOC will quickly say data still matters, even if it isn't in a disparate impact. All right, why don't we go to the next slide, please? And incidentally, I've seen some questions come up. Please keep them coming. If we don't respond to them during the course of the actual webinar, we'll try to get back with you with an email afterwards. So we welcome any questions you have. All right, media. This is, I think, one of the biggest concerns of employers when it comes to the EEOC. And the EEOC's used media for a long time. It's not a brand new shiny toy for them. Matter of fact, way back in roughly, it was 2005, 2006, Andy, you might correct me, but it's when they started their systemic initiative. One of their stated tools in their toolkit was, we're going to get the word out. When we sue somebody, we're going to make sure everyone knows about it to get that sort of secondary deterrence effect, get everyone's attention and realizing, oh, the EEOC might go after us for this. So that's not new. But what we're seeing with this EEOC is the degree to which it is using media is unprecedented, and which is consistent with the administration, right? This is an administration that very much leverages media, and we're seeing it, of course, with lots of government agencies, and the EEOC is certainly one of them. We see continued, we've mentioned press releases probably 20 times already during this webinar. They continue to make announcements of new litigation. They continue to make announcements on settlements. And those are the typical bookend sorts of press releases that we've seen in the past. But I'll throw it to you, Andy, your thoughts on media issues.
Yeah, well, I think we're seeing just a very striking shift in tone. Historically, we did see announcement of some new litigation and some settlements, And that was basically it. If you got an announcement from the chair, it would often be to, celebrate the anniversary of the ADEA, or, otherwise sort of, give the agency a pat on the back in some way, or maybe to announce that they, issued a new publication of some type. Here we're seeing much more aggressive use of the press release platform to make announcements by the chair about the agency's priorities. We're seeing them announce many more types of litigation, and we'll talk about that with our last bullet point here. We're also seeing Chair Lucas out there using other platforms. So she's a frequent poster on LinkedIn. She appears on Fox News and other TV shows. She's been profiled in the New York Times. And again, in ways that are different in tone than what we've seen in the past. And just to give you an example from yesterday, she had a post, I'll just read the start of it. Women's dressing rooms are for women. Every day, thousands of women in blue-collar frontline jobs change clothes, shower, and even sleep at work, often in isolated locations. These women are particularly vulnerable to sexual harassment and assault. EEOC is here to protect you. And this is consistent with some other messages that she sent around gender identity and transgender employees. So just, much more of a strongly stated point of view, I guess we could say. I did want to mention the subpoena enforcement issue, and I'm sure Chris will have thoughts to add on this. So by statute, an investigation by the EEOC is confidential. And the only way that the public would know about the investigation is if it turns into litigation brought by the EEOC, or if the employer decides to make it public for some reason. We have seen the agency initiate subpoena enforcement actions multiple times in recent months. And a subpoena enforcement action is intended to force an employer to turn over information that they've so far refused to turn over during the investigation. They ask a court to do this. But it has another effect here, which is to make the investigation public and to make public what the allegations are against the employer and what the EEOC is pursuing. And in some of these recent subpoena enforcement actions, we've seen evidence of the commission pursuing some of these new priorities, like challenging DEI programs or pursuing investigations related to anti-Semitism. And so this creates an interesting dynamic where the EEOC can seek information from an employer that the employer might have legitimate objections to turning over, even to overreach in those requests, because the EEOC might be able to achieve its goals by going public on a court docket to enforce those subpoenas, bringing to light what it is that they're pursuing and who they're pursuing and how they're doing it.
And if I could add in one critical point, during the investigation, the EEOC is supposed to be a neutral at that point. They are supposed to be weighing the facts and not making a determination until the end of the investigation as to whether someone has violated a statute or not, right? So we all know, as a matter of fact, that that doesn't happen. The EEOC, once it starts investigating, will definitely have its ideas of whether or not there's been a violation or not. But there has never been, or at the stage at which subpoena enforcement actions are being publicized, there has not been a determination of a violation of statute. So the EEOC is sometimes using this tool to get the word out when there could be absolutely no violation of the statute whatsoever, which of course, for the employers who are targeted, drives them crazy, right? Because they haven't had anything substantiated yet here's their name out there in an EEOC press release. So the EEOC knows what it's doing there. There's some deliberate use of the media in that way. And I think that it's an important reminder, though, for everyone to remember that at that point, at the subpoena enforcement stage, there's been no finding of liability. Somebody asked, what are our thoughts on a company making a counter statement, that becomes a true PR issue. Some folks want the news cycle to die down as quickly as possible, so don't make a statement. Others feel it's important to go ahead and start investigating what their options are for a counter statement. So those are non-legal issues, but they're important issues for our clients. And a lot of times we're partnering with crisis management teams to develop that part of the narrative as well, and asking the question, do we want to get a counter narrative out there, and what would that be? All right, next slide, please. What's to come? Look, we have a very active EEOC right now. I'll hand it over to Andy to kick us off on looking into the crystal ball.
Sure, thanks, Chris. So again, here I would expect Chair Lucas's views of things to drive what we see from the EEOC over the course of this next year. And she's made very clear that she wants to focus on disparate treatment claims and making sure that people who in the past the EEOC had not maybe focused on feel like they can bring their charges. And so she's been explicit that, you know, if you're a white man who feels you've been discriminated against, the EEOC is here to hear your allegations. We've put on the other slide some of the other priority announcements that she's given. And I think one important thing to keep in mind is that the EEOC recently changed its litigation delegation rules. And previously, the regions had a good deal of autonomy to bring those kinds of bread and butter cases that we talked about before, and they only had to seek approval for the big swing cases. And now every litigation matter has to go to the commissioners for a vote. And so I think we're going to see that power exercised in a way that devotes more of the EEOC's resources to these priority areas. So challenging DEI, you know, bringing cases related to anti-Semitism, bringing cases that, if they can find them, of somebody claiming that they were harassed or felt discriminated against because they had to share a bathroom with their transgender coworker. I think we're going to see more litigation, and we're going to see it more focused on the announced priorities of Andrea Lucas, because I think she has the complete buy-in of Commissioner Panuccio to jointly go forward on those priorities.
And I guess I'll throw this in here now, and we'll try to discuss it a little bit more in detail later, but what are some of your best practices? Everyone's asking, okay, well, what do we do? Okay. I think two big low-hanging fruit items are, one, do some robust training for your managers and decision makers. I know I sound like a broken record for those of you who've been on this in the past. It's good for a litigation narrative to say that everyone has been counseled on what is and is not appropriate in the workplace. But it also has the real world impact of decreasing claims. It works. So I would say robust training is a great shield to any litigation, including EEOC litigation. And the second thing that I would advise is that do a privileged, important underline privileged, audit of your policies and practices. Take a look. Is your pregnancy discrimination policy state of the art? Do you have the sorts of forms necessary to address religious accommodations? The things that the EEOC is interested in, take a look at your policies and see where they stack up. And not only that, dig a little deeper and find out how they're applied in the field, right? Because you can have the best policy in the world, but if folks out in the field aren't using it the way that they should, it actually can backfire on you. So those are two important items I would recommend for all of our listeners and friends today. We've already talked about a couple of the other points on that slide. Let's move to anticipated litigation areas. And Andy, why don't we talk about that?
Yeah, and we've touched on this as well, but we've seen from the start with this administration that they are going to go after DEI programs, and the EEOC has been quite clear that they are willing to take up that mantle too. I know of multiple investigations that are ongoing with the EEOC challenging an employer's practices, and we may see some of that turn into litigation if they can't be resolved at the charge stage. We've seen some of that poke through in some of these subpoena enforcement actions too, where we get a peek behind the curtain into ongoing investigations. I would expect this to continue to be a hot topic throughout the year for the EEOC. And then similarly, these majority group claims, again, Commissioner Lucas has been out there soliciting them with videos on LinkedIn and X and other platforms. And so as those charges continue to wind through, I do think we'll see the EEOC take on some of those claims as well, to remedy what they see as potential discrimination against men or against white employees. And I think they will. Sometimes that will be paired with a DEI claim. Maybe there are other theories that will be based on something else, but I do think we'll continue to see more litigation in that space.
And we already talked a little bit about, well, actually quite a bit now, about gender identity protections. It's just a good reminder. The EEOC once was truly the champion of these LGBTQ plus issues. They were pushing the edge of the envelope, creating new and important law on this subject. And now the EEOC has not only dropped those topics like a hot potato, but has also moved over to go actually to the other direction and are looking for ways of protecting your sort of rank and file populations against these sorts of preferential policies or anything that doesn't necessarily marry up with the administration's priorities. Remember, when Andrea Lucas was a commissioner, she indicated that the EEOC was an independent agency that operated sort of on its own without executive branch tethers. She has completely reversed course and said, oops, and almost this directly, I made a mistake. That's not true. We're not an independent agency. We're part of the executive branch. And guess who's the boss of the executive branch? President Trump. We're going to follow his agenda. Similarly, with religion cases, there's been an emphasis on Christian and Jewish employees. Time will tell here in 2026 whether other faiths are going to seek or going to receive rather the same attention. We haven't seen a whole lot of evidence of that yet. And we're keeping our eye on some developing investigations anecdotally, and likely we'll have something more to report on that next time we all gather together. All right, James, we've got a couple of asks for the CLE code. How about we put that up?
Yeah, let's move on to the highlight of the presentation. Our CLE code for everyone online is SS3104. That's SS as in Seyfarth Shaw 3104. And you all can scan the QR code on the screen, which will pull up the CLE form for everyone to fill out. Leave it up on the screen for a moment.
That's 3104 if you all didn't get it down quick enough. I always need it repeated like 6 times.
Appreciate it.
Okay.
Maybe we can go to the next slide. So before we end today's program, we'd be remiss not to mention our EEOC-initiated litigation report. This is the book that we've referenced throughout the presentation, and it is our annual report that we've prepared for over 15 years that tracks and analyzes everything EEOC in a given year: filings, decisions, settlements, publications, guidance. And this is our comprehensive report that our team at Seyfarth takes much pride in. It's also worth noting that, as we've talked about today, a lot has changed and is continuing to change at the EEOC. But despite all that, this book is still an important resource for employers. It allows us to look at historical trends and the norm of what the EEOC has been, and compare that baseline against what the agency has been, the last few years, and what they're suggesting they will be focused on going forward. Everyone who signed up received a link already to the book, but if anyone needs a copy, feel free to reach out to any of the speakers or to go to our firm's website. Chris, before we sign off, do you have any last words for the group?
Just thank you to my co-presenters, of course, but thank you all for attending today. We had hundreds of you all from across the country and across so many different industries. So good to see everyone, some very familiar names, some folks that we haven't seen before. Thank you for attending, and know that we continue to put out a number of, over the course of the years, updates through our blog, www.workplaceclassaction.com. At the end of the book, there's a link to it. There's going to be links in the email we send to you, so you won't have any problem finding it. But that will give you up-to-the-minute updates on what happens between now and the next time we speak. But as always, we're standing by with our resources if you have any questions. But again, thank you so much for attending, and we'll just all buckle up for another interesting year with the EEOC. So take care.